Rights of persons charged with a criminal offense, General Comment No. 32, 2007 of Human Rights Committee. 31. The right of all persons charged with a criminal offense to be informed promptly and in detail in a language which they understand of the nature and cause of criminal charges brought against them, enshrined in paragraph 3a, is the first of the minimum guarantees in criminal proceedings of Article 14. This guarantee applies to all cases of criminal charges, including those of persons not in detention, but not to criminal investigations preceding the laying of charges. Notice of the reasons for an arrest is separately guaranteed in Article 9, paragraph 2 of the Covenant. The right to be informed of the charge promptly requires that information be given as soon as the person concerned is formally charged with a criminal offense under domestic law, or the individual is publicly named as such. The specific requirements of subparagraph 3a may be met by stating the charge either orally if later confirmed in writing or in writing, provided that the information indicates both the law and the alleged general facts on which the charge is based. In the case of trials in absentia, Article 14, paragraph 3a requires that, notwithstanding the absence of the accused, all due steps have been taken to inform accused persons of the charges and to notify them of the proceedings. 32. Subparagraph 3b provides that accused persons must have adequate time and facilities for the preparation of their defense and to communicate with counsel of their own choosing. This provision is an important element of the guarantee of a fair trial and an application of the principle of equality of arms. In cases of an indigent defendant, communication with counsel might only be assured if a free interpreter is provided during the pre-trial and trial phase. What counts as adequate time depends on the circumstances of each case. If counsel reasonably feel that the time for the preparation of the defense is insufficient, it is incumbent on them to request the adjournment of the trial. A state party is not to be held responsible for the conduct of a defense lawyer, unless it was, or should have been, manifest to the judge that the lawyer's behavior was incompatible with the interests of justice. There is an obligation to grant reasonable requests for adjournment. In particular, when the accused is charged with a serious criminal offense and additional time for preparation of the defense is needed. 33. Adequate facilities must include access to documents and other evidence. This access must include all materials that the prosecution plans to offer in court against the accused or that are exculpatory. Exculpatory material should be understood as including not only material establishing innocence, but also other evidence that could assist the defense, e.g., indications that a confession was not voluntary. In cases of a claim that evidence was obtained in violation of Article 7 of the Covenant, information about the circumstances in which such evidence was obtained must be made available to allow an assessment of such a claim. If the accused does not speak the language in which the proceedings are held, but is represented by counsel who is familiar with the language, it may be sufficient that the relevant documents in the case file are made available to counsel. 34. The right to communicate with counsel requires that the accused is granted prompt access to counsel. Counsel should be able to meet their clients in private and to communicate with the accused in conditions that fully respect the confidentiality of their communications. Furthermore, lawyers should be able to advise and to represent persons charged with a criminal offense in accordance with generally recognized professional ethics without restrictions, influence, pressure, or undue interference from any quarter. 35. The right of the accused to be tried without undue delay, provided for by Article 14, paragraph 3c, is not only designed to avoid keeping persons too long in a state of uncertainty about their fate and, if held in detention during the period of the trial, to ensure that such deprivation of liberty does not last longer than necessary in the circumstances of the specific case, but also to serve the interests of justice. What is reasonable has to be assessed in the circumstances of each case, taking into account mainly the complexity of the case, the conduct of the accused, and the manner in which the matter was dealt with by the administrative and judicial authorities. In cases where the accused are denied bail by the court, they must be tried as expeditiously as possible. This guarantee relates not only to the time between the formal charging of the accused and the time by which a trial should commence, but also the time until the final judgment on appeal. All stages, whether in first instance or on appeal, must take place without undue delay. 36. Article 14, paragraph 3, d, contains three distinct guarantees. First, the provision requires that accused persons are entitled to be present during their trial. Proceedings in the absence of the accused may in some circumstances be permissible in the interest of the proper administration of justice, i.e., when accused persons, although informed of the proceedings sufficiently in advance, decline to exercise their right to be present. Consequently, such trials are only compatible with Article 14, paragraph 3, d, if the necessary steps are taken to summon accused persons in a timely manner and to inform them beforehand about the date and place of their trial and to request their attendance. 37. Second, the right of all accused of a criminal charge to defend themselves in person or through legal counsel of their own choosing and to be informed of this right, as provided for by Article 14, paragraph 3, d, refers to two types of defense which are not mutually exclusive. Persons assisted by a lawyer have the right to instruct their lawyer on the conduct of their case, within the limits of professional responsibility, and to testify on their own behalf. At the same time, the wording of the covenant is clear in all official languages, in that it provides for a defense to be conducted in person or with legal assistance of one's own choosing, thus providing the possibility for the accused to reject being assisted by any counsel. This right to defend oneself without a lawyer is, however, not absolute. The interests of justice may, in the case of a specific trial, require the assignment of a lawyer against the wishes of the accused, particularly in cases of persons substantially and persistently obstructing the proper conduct of trial, or facing a grave charge, but being unable to act in their own interests, or where this is necessary to protect vulnerable witnesses from further distress or intimidation if they were to be questioned by the accused. However, any restriction of the wish of accused persons to defend themselves must have an objective and sufficiently serious purpose and not go beyond what is necessary to uphold the interests of justice. Therefore, domestic law should avoid any absolute bar against the right to defend oneself in criminal proceedings without the assistance of counsel. 38. Third, Article 14, paragraph 3, d, guarantees the right to have legal assistance assigned to accused persons whenever the interests of justice so require, and without payment by them in any such case if they do not have sufficient means to pay for it. The gravity of the offense is important in deciding whether counsel should be assigned in the interest of justice, as is the existence of some objective chance of success at the appeal stage. In cases involving capital punishment, it is axiomatic that the accused must be effectively assisted by a lawyer at all stages of the proceedings. Counsel provided by the competent authorities on the basis of this provision must be effective in the representation of the accused. Unlike in the case of privately retained lawyers, blatant misbehavior or incompetence, for example, the withdrawal of an appeal without consultation in a death penalty case, or absence during the hearing of a witness in such cases may entail the responsibility of the state concerned for a violation of Article 14, paragraph 3, d, provided that it was manifest to the judge that the lawyer's behavior was incompatible with the interests of justice. There is also a violation of this provision if the court or other relevant authorities hinder appointed lawyers from fulfilling their task effectively. 39. Paragraph 3, e, of Article 14 guarantees the right of accused persons to examine, or have examined, the witnesses against them and to obtain the attendance and examination of witnesses on their behalf under the same conditions as witnesses against them. As an application of the principle of equality of arms. This guarantee is important for ensuring an effective defense by the accused and their counsel, and thus guarantees the accused the same legal powers of compelling the attendance of witnesses and of examining or cross-examining any witnesses as are available to the prosecution. It does not, however, provide an unlimited right to obtain the attendance of any witness requested by the accused or their counsel, but only a right to have witnesses admitted that are relevant for the defense, and to be given a proper opportunity to question and challenge witnesses against them at some stage of the proceedings. Within these limits, and subject to the limitations on the use of statements, confessions, and other evidence obtained in violation of Article 7. It is primarily for the domestic legislatures of states parties to determine the admissibility of evidence and how their courts assess it. 40. The right to have the free assistance of an interpreter if the accused cannot understand or speak the language used in court as provided for by Article 14, paragraph 3, f, enshrines another aspect of the principles of fairness and equality of arms in criminal proceedings. This right arises at all stages of the oral proceedings. It applies to aliens as well as to nationals. However, accused persons whose mother tongue differs from the official court language are, in principle, not entitled to the free assistance of an interpreter if they know the official language sufficiently to defend themselves effectively. 41. Finally, Article 14, paragraph 3, g, guarantees the right not to be compelled to testify against oneself or to confess guilt. This safeguard must be understood in terms of the absence of any direct or indirect physical or undue psychological pressure from the investigating authorities on the accused, with a view to obtaining a confession of guilt. A fortiori, it is unacceptable to treat an accused person in a manner contrary to Article 7 of the Covenant in order to extract a confession. Domestic law must ensure that statements or confessions obtained in violation of Article 7 of the Covenant are excluded from the evidence, except if such material is used as evidence that torture or other treatment prohibited by this provision occurred, and that in such cases the burden is on the state to prove that statements made by the accused have been given of their own free will.